Nope. Okay, I guess now we're good to go. I want to make sure everyone has their video and audio off except for contestants at this point. It looks like that has been done, so we're good to go. Next, if everyone could right-click on my name and make sure that you have hid all non-video participants. If you right-click my name and you see show non-video participants, that means that you need to change it, or that means that you've already done it. So make sure that you see that. You'll know it's right because you should only see 3 images on the screen if you've done that correctly. All right. I think we're all good to go. I'd like to start with introductions from the plaintiff, and after that, we can handle some housekeeping.
Yes, Your Honor. Good afternoon. My name is Benjamin Crosby, and I'm joined by my co-counsel, Mr. David Bainbridge, who is off screen. Mr. Bainbridge will be assisting me with the technology involved in today's trial as we represent Ethel Marks on behalf of her deceased daughter, Jessica Marks.
Good afternoon. And from the defense.
Hello, Your Honor. My name is Natalie Manoogian, and today I will be representing Sunny's Rooftop Bar, which is the defendant in today's case. I will be joined by my second chair, Elizabeth Baldwin, who will be assisting me with documents and exhibits in today's trial. We do have a party representative in today's trial. Should we introduce her now, or would you like us to wait?
Please do so now.
This is Sunny Mehta, and she will be in trial for the duration of proceedings today.
Good afternoon, Your Honor.
Good afternoon.
A few preliminary matters, Your Honor.
Yes.
Firstly, we'd like to draw the court's attention to the evidentiary rulings in the pretrial order. Specifically, one of the rules that we're going to display at this time, ruling number 11. And this rule displayed on the screen here notes that Exhibit 22 is pre-admitted and may be used at any time for any purpose. We bring this to Your Honor's attention because we plan on referring to this exhibit in opening statements.
Very well. And what is Exhibit 22?
Yes, Your Honor. We could display that at this time. It's an autopsy report.
Understood. Displaying it won't be necessary. I just wanted to know for my reference. Thank you very much.
Yes.
Any other housekeeping?
One more thing, Your Honor. We'd ask that the court invoke rules 603 and 615, which call for the constructive swearing in and sequestration of all witnesses, barring the party representatives that have already been identified.
Yes, and so all witnesses will be considered to be constructively sworn in as well as sequestered. Remind me, which parties have a party representative? Is it both of you?
No, Your Honor. The plaintiff does not have a party representative today.
Understood. Okay. And the defense, you do have a party representative, I remember.
Yes, Your Honor.
Excellent. Okay.
And with that, Your Honor, no, Your Honor. We're ready to go when the defense is.
Housekeeping from the defense.
Yes, Your Honor. We'd just like to know when we're displaying an exhibit for the first time, if we should do that without asking Your Honor's permission or ask Your Honor's permission before that first time.
You don't need to ask my permission. However, if you're going to show something constructively without showing the jury, please say that for the record. That way it's clear. Once the witness has laid the foundation, then we can publish it to the jury. And if you just request before publishing, that way we have a clear record.
Yes, Your Honor. We have no other housekeeping measures.
Okay. From my housekeeping, from my perspective, please do not engage in speaking objections. Please just state your grounds. And then afterwards, we can go to a constructive sidebar and we can hear objection arguments constructively outside the earshot of the jury.
Yes, Your Honor.
Very well. Are we ready to proceed?
The plaintiff is ready, Your Honor.
Excellent. All right, before we proceed to opening statements, I'm going to make another technology request. If you go to the top right-hand corner of your screen to our scoring judges, please make sure at this time that you're selecting the speaker view rather than the gallery view. That way you should only be able to see Mr. Crosby when he's speaking. All right, and with that, plaintiff, you can begin at your convenience.
Your Honor, opposing counsels, members of the jury, may it please the court. The signs were there, but they didn't care. It's March of 2019. Jessica Marks is in California on vacation with her friend Morgan Levin. They hit all the California basics, Disneyland, museums, a few bars. And on March 24th, they decide to go to Sunny's rooftop bar to get a few drinks. Jessica has had a few before they even get to the bar. And by the time they get there, she's already a bit tipsy. But the owner of the bar, Sunny Mehta, lets them in, brings them up to the rooftop. The two order a round of drinks, then another, then another, then another. Jessica starts to get more and more intoxicated. She's slurring her words together, but she keeps drinking. Eventually, it's time to go. Jessica stumbles into the parking lot, and her friend Morgan calls an Uber. But Jessica gets behind the wheel of her car. She says she's fine. She says she's okay. She says she's driven before after a big night. She only makes it 1,000 feet. Jessica's car drives over the median and over the edge of the road, tumbling into a ravine. Like that, Jessica Marks's life is over. She was 19 years old. When a young woman goes from taking her final drinks in a bar to her final breaths in a car, we're devastated. But the role of the bar in stories like that of Jessica Marks isn't just devastating, it's illegal. Mr. Bainbridge, if you would. Section 25602.1 of the California Business and Professions Code makes clear that when a bar sees signs that a customer should be cut off, but chooses to serve them anyway, they do so in violation of the law. That's why, members of the jury, we have brought a suit of wrongful death on behalf of Ethel Marks and the family of Jessica Marks. By bringing this suit, we as the plaintiff embrace a burden. And that's the burden to prove three things. One, that Sunny's rooftop bar sold, furnished, or gave an alcoholic beverage to Jessica Marks, who was a minor. Two, when Sunny's rooftop bar provided alcohol to Jessica Marks, she was obviously intoxicated. And three, that action was the proximate cause of the injury and death sustained by Jessica. And we need to prove those three things by the standard of a preponderance of the evidence, meaning that it is more likely than not. Today, we will meet this burden. You'll hear from someone who knew Jessica well and who was with her through that night, Morgan Levin. When Miss Levin takes the stand, we expect she'll tell you that the signs were there. That on March 24th, 2019, Jessica Marks was acting in a way that clearly showed she'd had too much to drink. You'll hear that Miss Marks showed up to the bar tipsy, was let in, and then was allowed to order drink after drink after drink. You'll hear that the bartender, Miss Mehta, was around and able to observe Jessica throughout the night. You'll even hear that Sunny Mehta caught Jessica as she stumbled and almost fell. She was so drunk. But you'll hear that the bar didn't care, and they continued to serve drink after drink after drink. You'll see that when her blood was tested at the scene of the crash, Jessica Marks registered a BAC of 0.16, 16 times the legal limit for a minor. By the end of this trial, I trust that you'll be convinced of three things. You'll know what the signs of obvious intoxication are that the defendant knew to look for. You'll know that Jessica Marks exhibited those signs on March 24th, 2019. And you'll know what the defendant did when they saw those signs. Nothing. It's for these reasons that I'll come before you at the end of this trial and ask you to hold the defendant Sunny's Rooftop Bar liable of wrongful death. Thank you.
Thank you very much, Mr. Crosby. Defense, do you wish to give a closing statement now, or are you reserving?
We have an opening statement.
Oh, I think I said closing statement. I'm sorry. Opening statement.
Yes.
Please proceed when you're ready.
Yes, Your Honor. Your Honor, members of the jury, they couldn't stop what they couldn't see. Mr. Crosby just told you a few things we actually agree with. He told you that on March 24th, 2019, Jessica Marks drove off the road into a ravine and died. That's true. He told you that before that crash, Jessica Marks was drinking at Sunny's Rooftop Bar. That's true too. He told you that that night, when Jessica Marks was being served at Sunny's bar, she was a minor. Unfortunately, that is true too. But what we disagree on, what isn't true, are the allegations that Jessica Marks's death was caused by the actions of the employees of Sunny's bar. That is not true. When someone dies horribly and tragically, it's in our human nature to want to find someone or something to blame. We want to make sense of a senseless tragedy. And that's what this case is all about, a horrible tragedy. But that doesn't mean that Sunny's bar is responsible. And it's not enough for plaintiff counsel to stand up here and merely assert that. They have a burden to prove. They must prove their claim of wrongful death by a preponderance, meaning more likely or not. Now, let's break that down. What do they need to prove? They need to prove that Sunny Mehta and the employees of Sunny's bar served an obviously intoxicated Jessica Marks, and that it was this serving of Jessica Marks that played a substantial factor in her death. Now, they're not going to be able to meet those elements today. They're not going to be able to prove their burden. And it's not enough for them to merely say that the defendant served a minor. They can't just stand up here and tell you that Jessica Marks was tipsy or drunk. They have to prove that she was served alcohol by the defendant when she was obviously intoxicated. So it's not about whether or not she was a minor or whether or not they knew she was a minor. It's about whether or not her actions, meaning her speech, her demeanor, the way she was acting that night, whether or not it would lead a reasonable person in the same position to think she was obviously intoxicated. They're not going to be able to prove that to you today. Now, plaintiff counsel told you about a witness they're going to call. Well, we're going to call our own. We're actually going to call the owner of that bar, Sunny Mehta herself. And we expect her to tell you that at no point in that night did she see Jessica Marks exhibit the signs of an obviously intoxicated person. We expect her to tell you that she walked through the bar without difficulty, that she never slurred her words, and that she left on her own. Now, we expect that the plaintiff will not be able to meet their burden because Sunny Mehta never saw those signs. They couldn't stop what they couldn't see. But members of the jury, this is a unique case, as we as the defense also have a burden of proof. We've taken on an affirmative defense. So let's break that down a little. At the end of today's trial, if you think the plaintiff has met their burden, or if you have found that the plaintiff has not met their burden, in fact, then the case ends there. But if you find that, yes, they did meet their burden, then you'll be asked to decide whether or not Jessica Marks's actions, her dangerous decisions, played any kind of effect in her own death. Now, let's walk through that evidence we expect you to hear and what we think will help you determine that. They told you that Jessica was drinking alcohol and that she drove drunk that night. What plaintiff counsel didn't tell you, what Mr. Crosby didn't tell you, is that she was already drunk driving before that. She arrived at the bar, already drinking. They told you that no one at Sunny's rooftop bar stopped Jessica from driving home that night. What they didn't tell you is that Jessica's best friend, the person who knew her best in the world, didn't think she was drunk enough to stop her from driving. Didn't think she was drunk enough to take her keys. Didn't think she was drunk enough to call for help. Now, we believe that after hearing from all these witnesses, it will be clear to you that Jessica Marks was not clearly intoxicated, and that Sunny's bar is not responsible for this death. Because they couldn't stop what they couldn't see. And that's why at the end of today's case, I'll review the facts with you one more time. I'll walk you back through the evidence, and I'll ask that you find Sunny's bar not liable for wrongful death. Thank you.
Thank you, counsel. And with that, the plaintiff can begin its case in chief. Plaintiff, please call your first witness.
Yes, Your Honor. Plaintiff calls Morgan Levin to the stand.
And while Ms. Levin is getting up there, if I could direct the audience at this point to please go to the top right-hand corner, click that view button again, and now you should be selecting gallery view. With that done, plaintiff, please proceed with your examination.
Yes, Your Honor. Ma'am, could you please introduce yourself to the jury?
My name is Morgan.
Ma'am, could you give us your last name as well?
Morgan Levin.
Why are you here today, Miss Levin?
You asked me to be here.
Miss Levin, I understand this is difficult for you, but could you give the members of the jury a bit of a picture as to what brings you here?
My best friend died, and I was the last person that was with her.
You say she was your best friend. How long had you known this woman?
Jessica and I had been friends since middle school.
Did you go to high school, college together?
We went to high school together. We went to college across the country from each other, but we kept in touch.
Miss Levin, after you parted ways for college, did you and Jessica see each other in person again?
Yes. She visited me in LA for spring break in 2019, our freshman year of college.
Miss Levin, as you know, I'd like to talk about that spring break trip. When did Jessica arrive in California?
March 18th of 2019.
Now, in March of 2019, how old were you and Jessica?
We were 19.
Ma'am, during that trip, did the two of you do any drinking?
Yes.
And how were you able to drink if you were under the legal age at the time?
Do I have to answer that?
Ma'am, for the members of the jury, would you mind explaining it to us?
Yeah, we had fakes. We had fake IDs that we used.
And would you recognize those IDs if I were to show them to you?
Yes.
Your Honor, at this time, outside of the purview of the jury, I'd like to show exhibits 3 and 4 at this time.
Please proceed.
Miss Levin, do you recognize these?
Yes, these were what we used. These were our IDs.
Do they look to be fair and accurate? Your Honor, plaintiff offers exhibits 3 and 4 into evidence.
Is there any objection?
Yes, Your Honor. To relevance? May I be heard outside of the view of the jury?
Yes, constructive sidebar, please explain.
Yeah, now we've already established, both of us, that they were drinking underage, that the bar was serving minors. Now this doesn't make, these fake IDs don't make anything in this case more or less likely when we've already agreed the bar was serving minors. It doesn't add anything to the case.
May I be heard, Your Honor?
Yes.
Two things, Your Honor. First of all, in the complaint and answer for this case, opposing counsel and the defense have actually denied, based on information or lack of belief, that they did serve minors in this case. So we're going about proving that Miss Jessica Marks was a minor at the time and that she was served by the defense. Second of all, given the nature of the claim that it's being brought today by the plaintiff, one of the things we have to prove is that Jessica Marks was a minor and was served.
Defense, your response to that?
Yes, Your Honor. Both parties agreed in opening statements, and as I said in opening statements, that she was a minor, that Sonny served a minor. We're all aware of that. That is not a fact that's contested today. We began our opening statements discussing that. There's no need for these to come in.
Counsel, I don't believe it was a stipulated fact based on my review of the stipulations. Correct me if I'm wrong. Objection overruled. Please proceed.
And maybe be published to the jury, Your Honor?
Yes, you may publish. Thank you for asking.
Yes, Your Honor. Ms. Levin, I'd like to talk about March 24th, 2019. Did you do anything together that day?
Yeah. Jessica picked me up from my dorm. We went back to her Airbnb, and then we went to the bar, to Sonny's.
Did you do any drinking while you were at the Airbnb?
Yes.
And ma'am, when you went to Sonny's rooftop bar, who drove the two of you?
Jessica.
Ms. Levin, did you feel safe driving with Jessica to the bar even though she'd been drinking a bit of wine?
I did. She seemed okay.
Did her behavior change in any way once you got to the bar, ma'am?
Yes. When we got there, I noticed that I didn't think she seemed okay anymore. Her eyes were bloodshot. She was loud. She was slurring.
In that state, ma'am, did they let you into Sonny's rooftop bar?
Yes.
Did Jessica Marks order any alcoholic drinks that night at the bar?
Yeah, we both did.
Do you know who took your orders?
I do. It was the owner, Sonny Mehta.
Ma'am, did you and Jessica have separate tabs that night?
No, we were just on one. I paid.
And did you get a receipt that night from Sonny's bar?
Yeah, I did.
Would you recognize it if I were to show it to you?
I think I would, yeah.
Your Honor, outside the view of the jury, we're displaying what's been marked as Exhibit 17 at this time. Ms. Levin, do you recognize this?
Yes, this is our tab from that night. It's my signature.
Has it been changed or altered in any way?
I don't think so.
Plaintiff offers Exhibit 17 into evidence.
Defense, any objection?
No objection, Your Honor.
Very well. The exhibit submitted.
And permission to publish to the jury?
You may.
Thank you, Your Honor. Ma'am, are these all the drinks that you ordered that night, what we see here?
I think so.
So which of the drinks on this receipt were yours?
Well, the first one's a bottle of wine. I had a glass from that bottle. I think Jessica had the rest. I had one of those beers, and I think one of the shots. That was mine.
So which of these drinks were Jessica's?
Everything else. The rest of that wine, the 3 White Claws, the other beer, and the other shot.
Did Jessica have any drinks that are not on this receipt?
I think so. Yeah, she had a drink that was like a mug with a straw that she got downstairs.
Ma'am, did you take any videos of your time at the bar that night?
I took one, yeah.
Your Honor, we're displaying at this time what's been previously marked as Exhibit 10 outside the view of the jury. Ms. Levin, do you recognize this?
Yes.
Is this that video you were talking about?
Yeah.
Plaintiff offers Exhibit 10 into evidence.
Defense, any objection?
No objection, Your Honor.
Exhibit 10 submitted.
Yes, Your Honor. Miss 11, do you remember when you took this video?
It was around 11 p.m. that night.
Your Honor, permission to play a short portion of this video?
Yes.
Mr. Bainbridge, would you start from about the 13-second mark? And are you able to hear this, Your Honor?
No, counsel, I'm not. I think you might need to enable that option.
Okay, I'm not sure if I have the authority to do that, Your Honor, but we will figure that out.
Bailiff, is there some permissions that need to be turned on for audio sharing? The court's going to take a short recess, just about 1 or maybe 2 minutes. I'm going to make a call very quickly, and then we'll reconvene.
Okay, yes, Your Honor.
Sorry to interrupt, guys, but I think if the individual who's playing the video, the co-counsel, let's make sure they're not muted. I can't see from my screen, but if we can make sure they're not muted, maybe it's just a matter of unmuting your own screen.
Mr. Bainbridge, could we try that?
I believe Mr. Bainbridge is still muted.
All right.
It's working. All right, this court is now back in session. We're back on the record. I'm sorry for the interruption to the jury and to counsel. Mr. Crosby, please proceed with your direct examination.
Yes, Your Honor. Mr. Bainbridge, could we play that video?
$10 for a subset. But everyone here wants to be a model or an actress. I'd like to thank the Academy. Mom and Dad inspired me. Okay, well, go big or go home.
Miss Levin, is this how Jessica was acting while you were at Sunny's bar?
Yes.
Do you remember her appearance and behavior throughout the night?
I do.
Your Honor, at this time, we're going to be displaying a visual aid where we're going to be noting the appearance and behavior of Miss Marks as this witness describes those things, if that's all right with Your Honor.
Yes, and counsel, just to be clear, this is just to be used for demonstrative purposes. It will not be admitted as an exhibit.
That's correct, Your Honor.
Very well.
Miss Levin, could you describe Jessica's appearance and behavior throughout the night? Mr. Bainbridge, could you make note as she just does that?
I can. She was drinking a lot. She was slurring. Her eyes were red and watery. I mean, you could smell the alcohol on her. She lost her balance once she even stumbled down the stairs.
Miss Levin, let's talk about that last bit. When did she stumble?
It was around 10, I think. It was on the stairs of the bar.
Was anyone around to help or catch Miss Marks?
Actually, the bar owner was. I mean, Jessica ran right into her.
Did Sunny Mehta say anything when Jessica almost fell down?
She did. She looked at the bartender and she said, "We might need to cut this one off."
Did Miss Mehta continue to serve Jessica drinks after that incident?
Yes, for almost 2 hours.
When did you eventually leave Sunny's rooftop bar?
It was around 11:45, 11:50.
Did you drive together, ma'am?
No,
And why not?
I thought Jessica I didn't want to get in the car with her. So I called an Uber and I tried to get her to come with me. She drove.
Thank you, Ms. Levin. And thank you, Your Honor. No further questions.
All right, counsel, thank you very much. Cross-examination,
Yes, Your Honor.
please proceed.
Ms. Levin, you told us a lot about the behaviors and signs that Jessica was exhibiting. Let's talk about how certain you can really be about that. You also had drinks on March 24th.
Yes.
And at this time, can we pull up, Ms. Baldwin, can you pull up Exhibit 17, which has already been entered into evidence and published to the jury? Now, that's your signature on the bottom of this receipt, right, Ms. Levin?
Yeah, I signed it. I paid the tab.
You made a mistake when you were paying the tab, right?
I added wrong. Yeah.
Yeah, we can agree that 19 plus 20 is actually 39.
Yeah. I was buzzed.
In fact, you were buzzed enough that you weren't going to drive you and Jessica home.
No.
Now, you talked a lot about Jessica's behavior at the bar. You agree that you knew Jessica extremely well, right?
She was my best friend.
So you knew what she was like when she was drunk.
Yeah.
You knew what she was like when she was sober.
Of course.
Now, neither of you had ever been to Sunny's before the 24th, right?
Right. Yeah, it was our first time there.
So they didn't know if Jessica spoke more loudly than normal when she was drunk, right?
I can't tell you what other people know. I'm sorry.
Well, that night, when Jessica arrived to the bar, you guys had already been drinking.
That's right. We had a glass of wine each.
You thought Jessica might have had two.
Maybe. I mean, I didn't really see her pour a second one, but it's possible.
So the people that worked at Sunny's bar never saw Jessica completely sober.
I mean, I guess you could say that. Yeah, her eyes were bloodshot from the minute she walked in.
Now, they wouldn't know how usually coordinated Jessica was.
I guess not. I mean, I don't know what they would know. I figure they're trained in that kind of thing. At least I thought so that night.
Yes, but they wouldn't be able to tell you if Jessica was more of a clumsy person or less of a clumsy person, right?
Look, I don't know. All I can tell you is what I saw. She stumbled down the stairs. I don't know what other people would be able to tell you. I can tell you that night, I assumed they had the training to cut my friend off if they thought she had too much. I didn't know it was my job.
Miss Levin, I know this must be incredibly difficult for you.
I lost my best friend, my best friend. You don't know what it's like.
My apologies. Would you like a minute to collect yourself, Miss Levin?
No, I'm fine. Can we please just get this over with?
Okay. They wouldn't know what Jessica acted like sober, right?
I guess not.
But you did.
Yes, I knew my best friend.
You cared about Jessica.
Yes.
You had been friends for years, since junior high, right?
Yes.
You look after your friends, right?
Yes.
You wouldn't knowingly put her in harm's way.
No. But that night, we all know I wasn't making the right decisions. I trusted that somebody there would have. I regret every single day letting her get in that car, but I did.
if you had thought Jessica was in serious danger, you would have stopped her, right?
I didn't trust my own judgment at that point. I thought that I didn't know it was my job to take her keys, okay? I thought that if she was that drunk that somebody would have stopped her. The owner was serving us. They knew how much we were there. They knew how much we were drinking. I didn't know it was my job to take her keys in that parking lot.
No. That night, Jessica reassured you she was fine, right?
She did. I never should have believed her.
She reassured you throughout that night that she was not drunk.
That's what she said.
Thank you, Ms. Levin, for your time. No further questions, Your Honor.
Plaintiff, is there any redirect?
No redirect, Your Honor. May Ms. Levin step down?
Yes, thank you for your time, Ms. Levin. You may be excused.
And with that, Your Honor, the plaintiff rests our case in chief.
Very well. Before we begin the defense's case in chief, are there any motions that need to be heard outside the earshot of the jury?
Not from the plaintiff, Your Honor.
Not from the defense, Your Honor.
Excellent. Would you both like to take a break or would you like to proceed?
Your Honor, plaintiff is ready to proceed if defense is.
We are as well.
Very well, let's proceed then. Defense, please call your first witness.
Yes, Your Honor. At this time, we call Sonny Mehta to the stand. May I proceed?
Please.
Please introduce yourself to the court.
Hi, my name is Sonny Mehta.
Can you tell us a little bit about yourself?
Sure, I mean, I'm in between jobs right now, but I used to be a bartender and the owner of Sonny's Rooftop Bar in Malibu.
Now, what goes into opening and running a bar?
It's a ton of work, but it was my passion project. I always wanted to own a rooftop bar, especially on the beach, because I love the beach. But you got to get a liquor license. You have to hire the right staff, and just a lot of work goes into setting up the bar to make sure it's ready to go.
Did you obtain a liquor license?
Of course, yeah.
Tell us a little bit about that process of obtaining a liquor license.
Sure, you have to go through the state to get certified in order to sell liquor, and everybody has to take a course to make sure that it's safe to sell liquor from your bar.
Well, what does that course cover?
A lot of different stuff, how important it is to make sure that people are of age, how to look out for people who have drank too much, all that good stuff.
And do you require your employees to take and pass that course?
Yes, absolutely.
Now, you mentioned that part of that training was recognizing the signs of intoxication. What are some of those?
Well, off the top of my head, the main ones I can think of, red eyes, slurred speech, loss of motor function, like tripping and falling all over the place, just to name a few.
How do you decide if someone is obviously intoxicated?
It changes from person to person because everybody handles their alcohol differently. So I can't really give you a specific answer to that question. Sorry.
To your knowledge, have you ever served an obviously intoxicated person?
No, I would never do that.
Let's talk about the night of March 24th. Did you know Jessica Marks?
No, the time that she came into my bar, that was the first time I ever met her.
When she came in that evening, were you aware whether or not she had been drinking?
I had no idea.
You say you met her for the first time that night. Did you have any idea what Jessica Marks acted like sober?
No, I couldn't tell you.
You mentioned you're trained to look for signs of someone being obviously intoxicated. Did Jessica look like she was obviously intoxicated?
When she first got to the bar, no, I didn't notice anything out of the ordinary.
Would you have any way of knowing whether or not Jessica was a clumsy individual?
No,
Would you have any way of knowing if she was an outgoing, loud individual?
I didn't know anything about her.
So what could you, as a server, seeing someone for the first time, look for in a person when they're drinking?
Well, a variety of different things, but mainly I would just look to see if their behavior changes from the moment that they come into the bar to the moment that they leave.
And at any point, did you see Jessica displaying signs of being obviously intoxicated?
No, I didn't notice anything from Jessica that was out of the ordinary.
Now, we've talked about Miss Marks. I'd like to talk to you about someone else you served. Did you serve drinks to Miss Levin that night?
I did.
Did you notice any of the aforementioned signs in Miss Levin?
Are you talking about the signs of intoxication?
Yes.
Sure. You know, she definitely looked a bit more intoxicated than Jessica. I noticed that she was the one who was stumbling and kind of slurring over her words a little bit, more so than Jessica.
Were you concerned for Miss Levin?
No, it was nothing to spark any serious concern. It was just something I noticed.
Were you worried about Miss Levin driving home that night?
I was. It got to the point where I didn't think that she should be the one driving home. So I asked to make sure that she wasn't the one who was driving home.
Now, before they left, was Jessica slurring her words?
No, I never heard that.
Was she being loud?
No, nothing out of the ordinary.
Were her eyes red and watery?
I didn't see that.
Did you ever see her stumble?
No.
At any point in that night, did you see Jessica stumble down steps and into you?
No, I heard Miss Levin say something like that back when she was testifying, but that never happened.
What did happen when Jessica and Morgan left that night?
I watched them walk down the steps and go out to where I'm assuming their cars were.
And did you notice anything out of the ordinary?
Not with Jessica, but again, I just noticed that Morgan was the one who was stumbling down the steps.
Did you see them again after they left your bar?
No. I got in my car after my shift was over and I started driving. I drive down Pacific Coastal Highway and I saw all of the police cars and the ambulances and the fire trucks. And later I found out what had happened to Jessica. It was horrible.
Thank you, Ms. Mehta. No further questions at this time, Your Honor.
Thank you very much. Cross-examination.
Yes, Your Honor.
Please proceed.
Good afternoon, Ms. Mehta. My name is Benjamin Crosby, and I'll be asking you a few questions on behalf of the plaintiff.
Hello.
Ms. Mehta, you were the owner of Sunny's Rooftop Bar, right?
Yes, I was.
As the owner of a bar, you knew that it is important to serve drinks responsibly, right?
Absolutely.
That means not serving to underage customers.
Yes.
And that means never serving alcohol to somebody who is obviously intoxicated.
Correct.
So, ma'am, you and your employees, you got training that helps you identify obviously intoxicated people.
Yes, we had that training.
So you're familiar with the signs of obvious intoxication then?
Yes, there's a bunch.
Ms. Mehta, I'm going to show you a few things, and I'd like you to tell me if there are signs you look for in determining obvious intoxication. Your Honor, I'm displaying that demonstrative aid one more time. And again, this will not be offered into evidence.
Please proceed.
Ms. Mehta, if something is a sign of obvious intoxication, please just say yes. Slurred speech?
Yes, that could be something I look for.
Red and watery eyes?
That could be a sign, yes.
Talking loudly?
Yes, if it changes over the course of a period of time, yes.
Objection, Your Honor, to substantially more prejudicial than probative. May I be heard?
Let's go to a constructive sidebar. Yes, please explain.
This is more prejudicial than it is probative. To have this defendant verify the signs of intoxication that we just heard the plaintiff witness list, it's not clear what's happening. It looks like the defendant is saying, yes, she was having slurred speech. Yes, she was having red and watery eyes. It's not clear that this side is Jessica's is what Miss Levin testified to, and that on this side is what the defendant is saying are signs of obvious intoxication.
May I be heard, Your Honor?
Yes.
Your Honor, the demonstrative aid does not mention the name Jessica Marks anywhere, and I'm simply asking this witness if these are signs she looks for in determining obvious intoxication. She's free to answer yes or no.
Your Honor,
Yes.
may I reply?
Yes, briefly.
We have seen this exact demonstrative aid, and they used it to list all of the symptoms that they believe Jessica was exhibiting that night through the testimony of Miss Levin. It is improper for them to then have the defendant check yes to those symptoms without her knowing what is being said. I mean, they're connecting something that doesn't need to be connected, and it's prejudicial. It's not probative in today's case. Well, it's not substantially more prejudicial than it is probative, Your Honor.
I understand the argument you're making, Ms. Manoogian. However, this isn't viewed in a vacuum. The jurors are hearing the questions, they're hearing the answers, and I believe that they'll be able to make the linkage. If you think that later on this is being used improperly to suggest something that wasn't elicited during examination, please re-raise your objection. But for now, the objection is overruled. Please proceed, Mr. Crosby.
Yes,
Yes, Your Honor. Ms. Mehta, are you still with us?
I am.
All right. We'll continue with these questions. Is a strong smell of alcohol something you look for in determining obvious intoxication?
Yes, that could be something I look for.
And how about a loss of balance?
That as well, yes.
All right. Well, then I'd like to talk about somebody who was in your bar on March 24th, 2019. You remember Jessica Marks?
Of course, yes.
You said that she and a friend came into your bar around 9 p.m. that night, right, ma'am?
Yes, that's true.
I'd like to get a picture of what you saw. You remember that Jessica was around 5 feet tall.
Yes, I remember that.
You think that she looked like she was maybe 110 pounds?
Yes, she was a smaller woman.
And ma'am, it's very important to you to not serve minors, right?
Yes.
So you have a personal policy of checking the ID of anybody who looks like they're younger than 45.
That's right.
So you certainly checked the IDs of Miss Marks and her friend that night, right?
I'm sure that I did, yes.
Your Honor, we're displaying what's been already entered as Exhibit 3. Miss Mehta, you say that you're sure you saw this ID that night.
I'm sure that I checked the IDs, but I don't remember if this was the ID that I saw.
Well, actually, Miss Mehta, let's be very clear here. You're sure that you saw this ID that night?
I'm sure that I checked the IDs, but I don't remember if I saw this specific ID that you have on the screen.
Ms. Mehta, just to clarify, is it your testimony today in court that you're not sure whether you saw this ID on March 24th?
Yes, I don't remember if this ID that you have on the screen is the one that I saw.
All right. You remember preparing a statement and being deposed before trial, right?
Yes.
You'd recognize that deposition if I were to show it to you?
I would.
All right, we're going to go ahead and, Mr. Bainbridge, could we pull that up? Your Honor, we'd like to display at this time what's been marked as the defendant's deposition.
Okay.
And if we could scroll and get a look at the pages, and especially the last page with the signature. Ms. Mehta, this is your deposition, right? Once we get to the signature page. Or the last page, rather. And the first page with the defendant's name. This is yours, right?
Yes, that's my name.
You were able to look and review this document before trial today?
Yes, it's my oral deposition.
Mr. Bainbridge, could we go to page 23? Or I'm sorry, page 10, rather? Ms. Mehta, I'm going to go ahead and read out a full question and answer. If you would just read silently along with me. I'm at question 9. How can you be sure you saw exhibits 3 and 4? Answer, I card anyone who looks younger than 45. Did I read that correctly?
Yes, you read that correctly.
All right, thank you, Mr. Bainbridge. Ms. Mehta, when you looked at this ID in preparation for this trial, you were able to identify it as a fake in 1 second, maybe 2, right?
When I was deposed, yes.
And that's because you say this is a very bad fake ID.
Yes, that's what I said in my deposition.
You said that because it doesn't make any mention of things like height, weight, or gender, right?
That's correct.
Ma'am, you served Jessica Marks alcohol on March 24th, 2019, didn't you?
Yes, I served her alcohol.
All right, well, I'd like to know how closely you were paying attention to Ms. Marks that night. You remember that Jessica was sitting at table 4 with her friend Morgan.
Yes, I remember that.
And you say that all the drinks that went to that table are on a receipt that Morgan paid.
To the best of my knowledge, yes. I wasn't the only bartender who was working.
We're going to display what's been already admitted as Exhibit 17. Ma'am, you can't tell us which of the drinks on this list were ordered by Morgan and which were ordered by Jessica, can you?
The receipt doesn't tell you that, no.
And you didn't watch to see how many drinks Jessica was actually consuming that night?
No, that's not something that I was counting.
Just to be very clear, ma'am, you do know that there were drinks that went to table 4 that are not on this receipt.
I think so, yes.
You think so, or you know?
I think so.
So, ma'am, is it your testimony today that you do not know for a fact that there were drinks that went to table 4 not on this receipt?
I wasn't the one who brought them out, but I think that you're referring to what I learned later in my deposition, that the other bartender gave drinks.
So, ma'am, let's be very clear then. You know for a fact that there were drinks that went to table 4 not on this receipt, right?
That's what I learned in my deposition, yes.
And you just don't remember how many?
I wasn't the one who delivered them, no.
Miss Mehta, you say that you didn't see Jessica Marks acting intoxicated that night in your bar, right?
That's correct.
You've been sitting in court all day today?
I have.
You saw a video of Jessica Marks in your bar?
I did.
And you say that if you had seen Jessica looking and sounding that way, you would have concluded that she might be intoxicated?
Yes, but I never saw that.
Ma'am, at one point in that evening, you asked Jessica and Morgan whether they'd be driving that night, right?
Yes, that's true.
Jessica told you that she was going to get in her car and drive, right?
Yes.
After she told you that, you did not stop serving her drinks, did you?
No, she seemed fine.
I have no further questions, Your Honor.
Thank you. Any redirect?
Yes, Your Honor.
Please proceed.
Ms. Mehta, they just asked you about a video they showed in court today. Do you remember that video?
I do.
At any point in that night, did Jessica ever act the way she was acting in that video in front of you?
No, absolutely not. That was completely different than what I saw with the Jessica in front of me.
If you had seen Jessica acting obviously intoxicated, would you have served her?
No, and I don't think she was acting obviously intoxicated in that video either.
Thank you, Ms. Mehta. No further questions, Your Honor.
Any recross narrowly within the scope of the redirect?
No recross, Your Honor.
All right. Thank you very much, Ms. Mehta. You may be excused. Defense, do you have any further witnesses you'd like to call?
No, at this time, the defense rests our case in chief.
Excellent. All right. Well, hey, I'd like to take around a 5-minute break now. I have the time as being 3:55 my time. So let's try to be back at 4 o'clock p.m. or the equivalent Eastern Standard Time.
Yes, Your Honor.
Yes, Your Honor.
All right, now I just want to make sure, well, I guess I'm a little bit early, but to our judges that are present, if everyone could just turn the camera back on, that way I can verify that all of our jurors are present. I want to make sure we don't leave anyone behind. All right, thank you, Joseph. I have you. Joshua, I have you as well. Zach. Perfect. Is that everyone? Do we have 4 or 5 this round?
I believe there's three jurors, and then use the presiding judge, Your Honor.
Perfect. All right, then I think we're ready to begin. Before we go to closings, are there any motions that either side would like to make outside the presence of the jury?
Not from the plaintiff, Your Honor.
None from the defense, Your Honor.
Very well, then we'll call the jury back in. And with that, plaintiff, would you like to proceed with closing statements?
Yes, Your Honor.
All right, please proceed whenever you're ready. Oh, I'm sorry, Mr. Crosby, my apologies. Before we begin, just a note to the audience, if you could switch your view now by going to the right-hand corner and make sure you select speaker view. All right, thank you, Mr. Crosby. I apologize for that. Please proceed.
Yes, Your Honor. Your Honor, opposing counsel, members of the jury, may it please the court. Today, you've been told by the defense that they couldn't stop what they couldn't see. The question that begs, what couldn't they see, members of the jury? The answer is that they saw, Sunny Mehta saw, her employees saw what they wanted to, because the signs were there, but they didn't care. In a few moments, Judge Welsh will instruct you on the law. He'll tell you that when we as the plaintiff brought this suit of wrongful death, we had to prove the elements of our claim by the standard of preponderance of the evidence. We'll get to that standard in a bit, but I'd like to spend some time first on the prongs of the claim that standard is applied to. A suit like this one that claims wrongful death must prove 3 things. And we told you what those 3 things were in our opening statements. 1, that Sunny's rooftop bar sold, furnished, or gave an alcoholic beverage to Jessica Marks, who was a minor. 2, that Sunny's rooftop bar, when they did so, were providing alcohol to somebody who was obviously intoxicated. And 3, that action was the proximate cause of the injury and death sustained by Jessica Marks. That's what we had to prove. And as I mentioned, we had to do so according to a burden of proof, a burden that we as the plaintiff and we as the plaintiff alone embrace. And it's an important one. We had to prove these 3 things by a preponderance of the evidence, meaning more likely than not. Putting that burden into perspective, it means that you simply need to see that there is a greater than 50% chance that the defendant did what we were alleging. Today, we met that burden. You saw that the signs were all there on March 24th, 2019. And you saw that the defendant simply didn't care. The signs were there that Jessica was a minor. You saw the fake ID that was obviously fake, that Miss Mehta herself told you was obviously fake. And you know, they didn't care. They let her in. The signs were there that Jessica was intoxicated, that she arrived to the bar already tipsy. You heard that things got worse as the night went on, and that she displayed the signs of obvious intoxication. But don't just take my word for it, members of the jury. Take Miss Mehta's. You see, in this trial, you heard the type of things that are signs of obvious intoxication. Miss Mehta illustrated those things for you. And you heard from Morgan Levin that those are the ways that Jessica Marks was behaving in at that bar. You heard that her speech was slurred. You heard that her eyes were bloodshot, that she was abnormally loud, that she stank of alcohol, that she lost her balance and fell onto Sunny Mehta. It didn't matter because the defendant didn't care. They continued taking her orders. They continued serving her drinks. You saw a recording, a video taken of Miss Marks in that bar on that night. You saw how she was behaving. Miss Mehta told you, if I'd seen that, I would have been concerned. I would have thought that she was probably drunk. I just didn't see that. But you can look at that video, members of the jury. You can see that it was posted at 11:11 p.m. on that night at that bar. You know that Jessica and her friend didn't leave that bar for another 40 minutes. So what couldn't they see? As the defendant was serving drinks, going to the table, interacting with Jessica Marks, what couldn't she see? The signs were there and she didn't care. The signs were there that Miss Marks was going to drive, putting herself and her others at risk. Members of the jury, she looked Sunny Mehta in the eye and told her, I'm going to drive. She didn't care. They brought her a round of shots before she walked out the door. Today, the defense of Miss Mehta and her bar is, I didn't see. She told you that someone who behaved the way that Miss Marks did in the video would tick some of those boxes, would be concerning, but she didn't see. She told you that Miss Marks was in her bar for 40 minutes after the video and she didn't see. She heard that she would be driving. She knew that she was drinking, but she kept serving. People don't overlook things like this, members of the jury. Miss Mehta certainly doesn't. She's a professional. She told you as she took the stand, I know why it's important not to serve minors. I know why it's important not to serve somebody who can't make decisions for themselves. She knew, but she did it anyway. In cross-examination, Miss Mehta said, when she was asked whether she cut the defendant off or cut the victim off after being told that that woman was going to get in a car and drive away, well, Miss Mehta told you, no, I wasn't concerned about Jessica. And doesn't that just put the case of a defense in a nutshell? Positive sentiments and regrets are not enough in a case like this. We all agree that this was a tragedy, but the law says that when the bar plays an active role in a story like this, a role so active that they are the proximate cause of a young woman's death, I'm sorry, isn't good enough. Hold Sunny Mehta liable. Thank you.
Thank you very much, Mr. Crosby. Defense, closing statement.
Yes, Your Honor. May I proceed?
Please.
Your Honor, members of the jury, they couldn't stop what they couldn't see. Now, today you heard a lot about Sunny's bar. Mr. Crosby told you that the signs were there, they didn't care. But you heard time and time again in trial today that they didn't see the signs and that they really did care. Now, Mr. Crosby just tried to tell you a story, placing all the blame on Sunny's bar. But you heard today that this story is a lot more complicated. It's not just about one business who took risks. It's about an individual that made dangerous decisions that led to her death. Now, we didn't come here today to tell you that Sunny's bar was perfect. We admitted in trial today that they made mistakes. They served alcohol to a minor accidentally. But we also know is that you heard on March 24th that when Miss Marks came to Sunny's bar, she was already drinking. She had already drove to the bar that night. And she was with one of her closest friends who knew what she was like when she was sober and what she was like when she was drunk. Now, the plaintiff has focused on the owner of the bar, on the fact that Miss Mehta didn't stop Miss Marks from ordering more drinks. Well, what you heard today was that Miss Mehta was looking for those signs. She's certified, she's trained, she knows what to look for. She listed them off to you today. Is it reasonable to think that she would have completely ignored them? That she would have purposely ignored those when her business was in jeopardy if she did? No. Is it more reasonable to think that Jessica Marks was not showing all the signs of being drunk? That she wasn't clearly or obviously intoxicated that night? Now, it doesn't matter that she was a minor that night. What matters is how her actions looked to the employees of Sonny's. And what you heard today is that they saw no signs, and they really did care. Now, the plaintiff has had a burden of proof in today's case. They had to prove to you by a preponderance of the evidence two things. They had to prove that Sonny Spar's employees were serving an obviously intoxicated Jessica Marks, and that it was that over-serving that was a substantial factor in her death. Now, members of the jury, the plaintiff could not prove these elements to you. They didn't meet their burden. But before we talk about that, I want you to remember something I told you at the beginning of today's trial. Even if you believe the plaintiff has met their burden, you still have to decide whether, you still have to consider what Mrs. Marks' role was in her own death. You have to consider what was her decisions and did they play a role in that death? Let's talk about what you heard today. You heard from Miss Levin, the best friend of Miss Marks who was there that night. And she told you on the stand today that she didn't trust herself. She told you, you heard on cross-examination, that she said she didn't trust her own judgment that night. So why should you trust her recollection? You heard throughout trial that she was drinking, that she was stumbling, that she was exhibiting signs of being drunk. But you also heard from Miss Mehta, who was sober that night, who was in charge of running that bar, who was making sure everyone was safe. Now, Miss Levin told you that she saw Jessica be clearly intoxicated, but she was also intoxicated. You heard from Sonny Mehta, who was sober that night, that she never, ever saw Jessica obviously intoxicated. Now, the plaintiff had to prove that Sonny's Bar sold that alcohol to someone who was obviously intoxicated, and they didn't do that today. You heard from Mr. Crosby that they did, but think back to that. You heard Miss Mehta under oath testify that she saw none of those signs. And yet Mr. Crosby put up an exhibit where she had checked all the boxes. Now, you heard about Miss Marks' own actions that night. What led up to her death? You heard that she insisted to her friend that she was fine, that she was fit to drive, that she wasn't drunk. And this was the person who knew her better than anyone in the world. The person who knew her when she was drunk, the person who knew her when she was sober. And that friend did not think that she was too drunk to drive. If she had, she would have stopped her that night. Find Sonny's Bar not liable. Thank you.
Thank you, Ms. Manoogian. Does the plaintiff have a rebuttal?
Yes, Your Honor.
Please proceed.
Ms. Manoogian asked you to consider what a reasonable bar owner would have done. I'd like you to do the same. Would a reasonable bar owner hear that a minor is going to drive home and then hand her a round of shots? Because that's what this defendant did. Hold her liable. Thank you.
Thank you very much. I think that concludes this trial. We're going to be giving comments soon, but first the judges need an opportunity to fill out their ballots. So again, I'm going to turn off my camera and I'll ask that when the judges have completed